Good evening, students. Today we will discuss a case wherein the conviction has taken place both under IPC and POCSO, and what are the sentencing principles that must be followed in such cases. So, without wasting much time, let us go on to the case. So, in this particular case, what has happened is that Mr. Gyanendra, who is the father of the minor child, the survivor that was involved, commits rape on this child when the mother is absent from the home. At this time, this minor child then decides to inform her grandfather, the father-in-law of her mother, and the father-in-law then informs the mother of the child, and the mother files a complaint. After which, this case has been brought forth, and the lower court punishes or convicts the accused both under POCSO as well as under the IPC laws. And a punishment of imprisonment for life is given to this accused along with a fine and so on. Now, we are restricting ourselves to the discussion as to when there are two acts involved, a special and a general law, and the conviction is there under these laws. How does one go about punishment, and what is the principle of sentencing that must be followed? Now, in this case, in this instance, the case was taken to the high court where it was dismissed, and the court did not intervene with the conviction that took place. But what it did do is that it modified the judgment and increased the punishment from imprisonment for life to the imprisonment for the entire natural life of the convict under section 376 of IPC, because this individual was punishable under section 376 as well as under 3 and 4 of POCSO. Now, 376 under these subsections of F and I provides for larger punishment as compared to what is available to us under POCSO under these provisions. So, then an argument arose that when POCSO is a special law and IPC is a general law, the special law must supervene and sentencing must take place through the special law. Now, when this case came to the Supreme Court, it was dealt with, and the court made reference to the relevant provisions, which are sections 42A and 42, and an interpretation of both the provisions were done in order to conclude what is the principle of sentencing which must be there when there are two laws involved, in this instance, which is POCSO and IPC. So the court first read through and interpreted section 42, which is that where an act or omission constitutes an offense punishable under this act and also under 166A, 354A, 354B, 354C, 354D, 370, 370A, 375, 376, and so on, notwithstanding anything contained in any law for the time being in force, the offender found guilty of such offence shall be liable to punishment only under this act or under the IPC as provides for punishment which is greater in degree. So, what has happened is the POCSO Act under section 42 has clarified that if an offense takes place under these provisions, under these sections, you are primarily expected to deal with them under POCSO, or there is a situation where you may deal with it under IPC, but that situation is when the punishment is greater in degree, which means that where IPC provides for a higher punishment, only in those such circumstances we will not refer to POCSO for punishment, we will refer to IPC because it provides greater punishment. So, this is what 42 says. What does 42A tell us? 42A tells us that the provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. And in case of any inconsistency, the provisions of this act shall have overriding effect on the provisions of any such law to the extent of the inconsistency. Now, this particular section has a different interpretation in context of when we do a literal interpretation of the section. It states that in case of an inconsistency with any other law, POCSO Act which will supervene. So the argument that came forth is here there is a inconsistency in context of punishment, and therefore the POCSO Act should actually be the one under which the punishment should be awarded. The court clarified that we are mixing up two separate provisions which deal with two separate perspectives. The court said that 42 deals with on a bare perusal in context of certain acts, which is those that they have provided for, and says that it will be dealt with under POCSO, but where IPC is providing a greater degree of punishment, it will be IPC through which the section will be dealt with. And we also understand that it has been clearly stated that it is in relation to punishment. The context has been clearly provided that yes, it is POCSO under which it will be dealt with, but if IPC provides a higher punishment, it will be dealt with under IPC. On the other hand, when you look at section 42A, it states that the procedural facet is in context of which 42A has to be interpreted. So 42 specifically deals with quantum of punishment, and 42A deals with procedural aspects of the provisions that are involved, and it is in that context that overriding effect exists and POCSO takes over any other law which is present in that particular case. So we see that 42A and section 42 actually deal with two very separate spheres. 42 deals with quantum of sentencing, and 42A deals with procedural aspects in context of two laws involved. And that has been clarified in para 21 and 22. And therefore, in consequence to that, it is clear that the appellant for the offences punishable under 376 subsection 2 F and I and sections 3 and 4 of POCSO Act, the decision is justified. So now we are clear that punishing under IPC is fair because we have had now an interpretation and understanding of section 42 and 42A. However, the decision is not over here. There is one last half of it where the court feels that the High Court has made a mistake in the quantum of punishment by extending it or increasing its rigor from imprisonment for life to imprisonment to the natural life of the individual, the remainder of his natural life, which is available under section 376. The court stated that through a plethora of judgments, there can be situations where death is not the right answer, where imprisonment, even at its lowest form, is not the right answer. And in such situations, even natural life may not seem to be the suitable answer or a solution for as punishment for that particular convict. So, referring to the case of Swami Shraddhanand, the court, and I've highlighted this part, it states that a reasonable and proper course in punishment would be to expand options and to take over whatever, as a matter of fact, lawfully belongs to the court, which is the discretion to give punishments which may not, which comes between this ambit of 14 years, which is generally usually interpreted, and death. It further referred to Virendra versus State of Madhya Pradesh and stated that In the case involving offences of POCSO and Section 376, subsection 2I of the IPC, confining the life imprisonment to mean actual imprisonment for a period of 30 years, while doing so, the bench relied on Swami Shraddhanand, which has previously already been referred to, hinting towards the fact that it is not necessary to give the punishment of imprisonment to natural life. Based on the case, based on the circumstances, decisions can change. Keeping in view the aforesaid judgments, the Supreme Court said that we therefore direct that for the ends of justice, to restore the judgment of the lower court, which was to give imprisonment for life, would be a better solution, right? And therefore, even though they did not feel that the interpretation of section 42 which they have provided for and the decision of giving punishment through IPC was wrong, what is relevant is that quantum of punishment should change in order to meet the ends of justice. So the court finally concluded by saying that the offences punishable under sections 376, the accused is sentenced to undergo imprisonment for life as awarded by trial court without stipulation that the life term will endure till the natural life of the appellant. So there are two perspectives that were brought forth. An interpretation of section 42 was done to tell us that IPC has to be the one that has to be referred if it provides for a larger quantum of punishment. And the second half, which I wanted to discuss, is even though that was established, the court did feel that the High Court erred in giving a punishment of life imprisonment, which meant the natural life of the individual. The court did partially, therefore, change that decision, that half, the punishment, because it felt it did not meet the ends of justice. I hope with this I was able to explain to you that where conviction is both under POCSO and IPC, punishment will be given on the basis of the law which provides for higher punishment, making reference to section 42 of the POCSO Act. I will show the first page of the case law again in case you want to make reference to the provision, to the case. Thank you, students.